to the Australian International Arbitration Act. We have many more possible amendments, probably around 20, but we've curated the list down to 10. I'll outline the 10 possible amendments in a moment, but to set the context, the UK Arbitration Act of 1996 has recently been amended. Singapore and Hong Kong are currently in the process of amending their arbitration acts. In contrast, Australia's International Arbitration Act has not undergone any comprehensive review for some 15 years. And we think that it is time for such a review to occur. So to explain the format of this evening, Luke and I will take it in turns to introduce each of the 10 possible amendments at rather breakneck speed. So think of speed dating. Meanwhile, a poll will be opened, which will give you 3 voting options in respect of each proposal: yes, no, or maybe. So please vote as we go along. At the conclusion of the session, Jacqueline from ACCI will compile the poll results and will display them, and so we can gauge which proposals have the most support, albeit this is hardly a representative sample. We will then invite questions and comments from the floor. Many of you might have other proposals that you think are more deserving than the 10 that we will outline this evening. So without further ado, the proposals that we will discuss are as follows. First, provision for enforcement of emergency arbitrator awards. Secondly, providing for statutory recognition of ARB-Med. Third, dealing with arbitrability of trust disputes between trustees and beneficiaries, so internal trust disputes. Fourthly, providing for a statutory default rule for the ascertaining the law of the arbitration agreement, but none has been expressly provided. Fifthly, court review of negative as opposed to positive jurisdictional rulings. 6, dealing with the perception that the lack of Australian law is a barrier to selecting Australia as a seat of arbitration. 7, dealing with the Australian consumer law, and in particular excluding its operation in arbitration seated in Australia involving foreign parties. And 8, excluding the proportionate liability regimes. 9, providing for confidentiality of arbitration-related court proceedings, such as setting aside stay applications, enforcement proceedings. And finally, establishing the Federal Court of Australia, the full court of the Federal Court of Australia, as the single intermediate court of appeal in matters under the International Arbitration Act. So the poll will now be opened, and I will get the ball rolling by starting with the first proposal, enforcement of emergency arbitrator awards. So as you all know, emergency arbitration is now a well-settled feature of the international commercial arbitration landscape. Most of the institutional rules that operate in our region provide for emergency arbitration. For example, ICC rules, ACCI rules, SEAC rules, to name a few. However, the status of emergency arbitrator awards in Australia is, well, it's not recognised by the International Arbitration Act. Are such awards enforceable? The Singapore International Arbitration Act and the Hong Kong Arbitration Ordinance specifically recognise emergency arbitrator awards, albeit in different ways, but the Australian IAA is silent. We think it's desirable that the IAA expressly recognise emergency arbitrator awards and provide for their enforcement. Now, for those of you that have just joined us, we are outlining 10 proposals. There's a poll that is opened with yes, no, or maybe. As we deal with each proposal, I've just dealt with proposal 1. please vote whether you agree, disagree, or you're sitting on the fence. But remember, if you sit on the fence, you get splinters. Now over to Luke to deal with topic 2.
All right, thank you. So ArbMed, why do we need a statutory reform? I've got 4 or 5 reasons. 1, generally arbitration is too costly and slow, and people are used to mediation, particularly in Australia. 2, it's already in the Commercial Arbitration Acts for domestic disputes. 3, ArbMed is quite common in civil law jurisdictions, particularly in our region, including Asia. And 4th, the proposal would be similar to the Commercial Arbitration Acts for domestic arbitration, so very conservative to address issues about possible bias or lack of equal treatment of the parties, even if they've agreed to this ArbMed. And so it's a dual consent. If the mediation attempts fail, one party or both can say, well, we don't want that person to continue as an arbitrator. And lastly, of course, this means you have to start again with an arbitrator, but you can have a clause drafted in to have a sort of backup arbitrator ready to step in. And of course, these days with e-proceedings, it's quite easy for a new arbitrator, hopefully, to pick up the pieces and keep going, give an award. So I'm done.
Okay, thank you. So now topic 3. Arbitrability of trust disputes between trustees and beneficiaries. Now, it's not uncommon for trust deeds to contain arbitration clauses providing for arbitration of disputes between beneficiaries and the trustee. So where the trustee arguably breaches his or her obligations in exercising powers, for example, distribution under the trustee. But there's an issue as to the arbitrability of such disputes, particularly involving beneficiaries who are not of age or who are not born, that is, unascertained beneficiaries. Such beneficiaries lack capacity to enter into a valid arbitration agreement. So in a discretionary trust, beneficiaries do not expressly agree to be bound by the terms of the trustee. And they therefore do not expressly agree to be bound by any arbitration clause contained in that deed. The ICC has drafted a model trust arbitration clause which seeks to deem consent in that situation to the arbitration clause. But there are serious doubts as to whether this solution would be effective to overcome the problem. It hasn't been addressed by the Australian courts. I'm not aware of any international court that has done so, but some of you might be, and I'd be interested to know what the approach was in those cases. In several jurisdictions, legislation has been passed to remedy the problem of lack of consent in the context of the arbitration of internal trust disputes, including in New Zealand and the UK. So different jurisdictions have contemplated different mechanisms to appoint representatives for the beneficiaries who lack capacity. In some jurisdictions, it's the arbitral tribunal that would appoint the representative. In other jurisdictions, like in New Zealand, it's the supervising court. So therefore, there would be an arbitration, and all beneficiaries would be represented. An alternative legislative solution would be that the Act could provide could simply deem that there was consent by all beneficiaries, but that's perhaps a less precise approach. Luke, topic 4.
All right. That was more than 2 minutes, Albert, so I'll have to speed up.
No, I spent 1 minute on topic 1.
Why do we need to have a default provision for the law governing the arbitration agreement? Well, 1, as I pointed out, 2009, in an article, and subsequently in my book in 2010 with Richard Garnett, there's a gap in the New York Convention regime in relation to stay of proceedings and therefore in the model law. The simple solution, the most elegant and logical, is to have the same default rule as for the law governing arbitration agreement when it comes to award enforcement, where we do have a provision. So it's the default is the law of the seat. That's what we put in the Akika rules 2016 as a default if you choose the Akika rules, but it should be in the law. Otherwise, we have endless litigation, and at the moment in Australia, it's a mess. And the dialogue case with Justice Beach, it's like he's got an even more complicated approach than the English case law, which gives priority, first of all, to the law, any express choice of the parties of the law governing the main contract, despite severability principle and different reasons why you might choose that law to govern the main contract. And so English law, English Act has been amended to switch to simply the law of the seat as the default. And that's the same as the majority of the rest of the world. So we should go down that track.
Thank you. Topic 5, court review of negative jurisdictional rulings. Article 16 of the Uncontrolled Model Law provides for review by the supervising court of a positive jurisdictional ruling by the arbitral tribunal. However, if the tribunal issues a preliminary ruling that it does not have jurisdiction, that is a negative jurisdictional ruling, there's no recourse to the supervising court. The Singapore International Arbitration Act in section 10(3)(b) supplements the model law to provide for court review of negative jurisdictional rulings as well as positive jurisdictional rulings. This is a sensible solution and should be followed in Australia. Luke, topic 6.
Is that other lack of Australian law? Isn't that you?
Oh, that's me. Lack of Australian law is a barrier to arbitration. Thank you for reminding me. Several legal luminaries, former Chief Justice Alsop and Professor Doug Jones, have expressed concern that the inability of parties to adopt Australian law as a governing law to determine the merits of their dispute is a disincentive to choosing an Australian city as a seat for international arbitration. This is because Australia is a federation and the law in the various states and territories, especially statutory law, differs. On the other hand, Australia's primary arbitration competitors in the Asia-Pacific region, in particular Hong Kong and Singapore, operate in unitary jurisdictions. And the question therefore arises whether the IAA may be usefully amended to provide for a definition as to what constitutes Australian law for the purposes of selecting a governing law in international arbitration seated in Australia. Luke, topic 7.
All right, so I've got 3 topics. First of all, should the parties, international parties to contracts, be able to exclude all or part of the Australian consumer law, which of course derives from our Trade Practices Act, but over the years it's added more and more bits. Stephen Reries gave a keynote lecture at a consumer law conference saying it's a legislative blancmange, which I think is a good description. And Max Bonnell, back in 2007, the Australian Law Journal, said it's Australia's arbitration headache. And why is that? Well, because despite its name now, the Australian consumer law, it applies, as we know, to many, many business-to-business transactions, which makes it almost pretty much unique around the world. And the problem is, especially if Australia is the seat, that various bits of the ACL may be held to be mandatory law, and the attempt to exclude it, for example, at the moment by choosing a foreign law may not be effective and jeopardise your reward ultimately, particularly if Australia is a seat, as Maya KC pointed out also a few years ago. And if we break it down in different sections, for the consumer guarantees, there's a choice of law provision, which Justice Edelman has interpreted to be a mandatory provision, but then other bits like misleading and unconscionable conduct and the unfair terms parts, which don't have a choice of law provision at all, and seemingly are mandatory, and this might infect the arbitration agreement and the awards. So the proposal is to allow parties to international contracts to exclude at least some parts of the ACL. All right, so secondly, moving on to another proposal, which is have something in the Act that excludes Australia's proportionate liability regimes.
That's topic 8.
Topic 8.
For the poll.
Tesseract decision, which came, and the reason for this is that was a big surprise. Albert has dug out submissions by Australia's arbitral institution saying they don't think that the proportionate liability laws introduced in the wake of the tort reforms 20, 25 years ago across the country in different states, and the Federation should apply in arbitration. Because you're trying to get everything to one proceeding, and so on, and you can't join others in arbitration like you can in courts. But it's unexpected. It's also almost a unique thing of Australian law. Other comparable jurisdictions have unitary liability, not proportionate liability. And thirdly, the claimant needs, therefore, to plan or start other proceedings because they only get proportional liability against the respondent in the arbitration. Or they have to find a way to themselves exclude the liability legislation. And this is very complicated because there are ways to do it, but you have to read Richard Garnett's article and so on and realise, oh, well, you need to choose Victorian law and a Victorian seat, or New South Wales law, and then a New South Wales seat, and remember to exclude specifically the proportionate liability legislation of New South Wales law, which is possible, but not in Queensland, So it's a total mess, totally unexpected, and we should just have a quick fix in the legislation so there are no surprises and Australia doesn't become a laughingstock. And the topic 9 is simpler, confidentiality of arbitration-related court proceedings. Now, why is this simple? Because, well, we know consistently through surveys and anecdotal evidence that confidentiality related to arbitration is seen as a mid-range advantage of arbitration over litigation internationally, particularly in the Asian region. Hong Kong and Singapore, secondly, have a prima facie confidentiality even when things get to court, to preserve that confidentiality so you don't lose it when things end up in courts, which increasingly they do, challenges to arbitrators and so on as well. And yet, finally, we've never dealt with it. I raised it in 2009, just keeps getting ignored. We finally, since 2015, got automatic confidentiality in relation to the arbitral proceedings themselves since 2015, but we haven't dealt with the question of confidentiality in court-related proceedings. And so the proposal is grasp that and it'll be like Hong Kong and Singapore.
Excellent. Thanks, Luke. So now I hope people are filling in the polls as we're going along. I should do it myself, but we come to topic 10, making the federal court the single intermediate court of appeal in matters under the IAA. Now, currently, we have 8 intermediate appellate courts in Australia, being the 9. We have 9 intermediate appellate courts in Australia exercising jurisdiction under the IAA. We have the 6 Supreme Courts, 2 Territory Courts, and the Federal Court, each with primary and appellate jurisdiction in matters under the IAA. Now, this is less than ideal in terms of legal infrastructure, and as we all know, legal infrastructure is a highly significant matter when it comes to the choice of an arbitral seat. Inherent in this unwieldy legal architecture is the potential for unseemly inconsistencies to develop between courts of appeal in decisions in matters under the IAA. And we've seen this before in arbitration matters. Witness the conflicting appellate decisions on the standard of arbitral reasons. Victorian Court of Appeal in Oil Basins, contrast the New South Wales Court of Appeal in Gordian Runoff. And then more recently, the approach to interpretation of arbitration agreements. And in that case, the very same arbitration clause. The New South Wales Court of Appeal in Welker contrasts the full court of the Federal Court in Hancock. Now, it's not a good look for our intermediate courts of appeal to disagree with each other in international arbitration matters. It means that parties have less confidence in choosing Australia as an Australian seat as an arbitral, an Australian city as an arbitral seat. So my proposal is to establish the Federal Court as a single intermediate appellate court in matters under the IAA. Under this proposal, the 8 Supreme Courts of the Australian states and territories and the Federal Court would retain first instance jurisdiction, for example, in dealing with stay applications, but all appeals would go to the Federal Full Court of the Federal Court. This proposal is much more moderate than the exclusive jurisdiction proposal that was first mooted by the Commonwealth Attorney General back in 2008, whereby the Federal Court would have exclusive jurisdiction in matters under the IAA and the Supreme Courts would be completely shut out. Now, there are precedents for this modest or moderate proposal in intellectual property statutes in Australia. So the poll will close in 2 minutes. Can I just suggest that for those of you that haven't done it, perhaps just before the poll closes in 2 minutes, just go through and record your results. So there's a poll button at the top of the page and you can just scroll through and 10 pages and just record your vote. Have you done that, Luke?
It's showing me that there's been 2 responses.
No, you've just got to create new responses.
I seem to have responded to everything, haven't I, Jackie?
I have now.
Anyway, I should probably vote.
Yes. So I went to the poll button at the top, and then on the right-hand side of the screen comes up each proposal with a yes, no, or maybe, and then you can scroll. You can just there's an arrow button on the right-hand corner, and you can scroll through the 10 proposals. Okay, we'll just wait a minute or so.
So just a reminder, when you get to the 10th question, to just click submit, and then
okay, hit submit. Thank you very much for that.
Yeah. So submit only comes through on the last question. So just go through 1 to 9 and 10. When you click submit, I'll get the results.
Sure. We only got 5
Jackie,
responses.
Didn't work for me. I've submitted, I think, correct? Can you tell?
Let's see. I think that. Give me a second.
It's saying my response.
Yeah. They're all anonymous, but yeah, more responses are coming in, so probably yes.
Okay.
Yeah.
Well, what we might do, we'll multitask. While people are filling in the poll, I'll open it up to the floor for any questions or comments. Oh, sorry. Yes, we have Stephen Raries. Would you like to say something?
Thanks, Albert. In your last one, question about having the Federal Court as the exclusive appellate court for the International Arbitration Act, you need to do it also for the Domestic Arbitration Acts as well, because otherwise you'll get inconsistencies there. It just becomes a problem with this stupidity of how the system is working federally. But unless you have one court that's going to decide all the questions as to how the model law is going to be interpreted, you can't leave the federal court with, the International Arbitration Act questions when the same questions arise under the model law as incorporated in all the state and territory acts.
Well, the answer is to that concern, a legitimate concern, is Section 2, capital A of the Domestic Arbitration Acts, which provides that the Domestic Arbitration Acts are to be interpreted consistently with the IAA. And so the federal court would take the lead in interpreting the model law, and the state courts would be required to follow the federal court's interpretation of the same provisions or analogous provisions.
Well, you hope. But, unless you just have one system and stream it, it's just going to be a disaster. But
you can't confer exclusive jurisdiction in the federal court to deal with all arbitration matters, because there will be a rump of disputes that don't involve corporations or interstate trade, etc., that the federal court wouldn't have jurisdiction over.
Anyway, maybe we need another seminar on the top 10 reforms of the Commercial Arbitration Act.
Yeah, and the same problem also arises. So Luke's fix for proportionate liability. You fix the problem for international arbitration acts. You can exclude it with a simple amendment to the IAA. But then to fix the problem at the domestic level, you'd need each of the state territory legislatures to introduce legislation. So it's much easier to fix it at the international level than the domestic level. Any other questions?
Andrew Payton has his hand up.
Yes, Andrea.
Hello, everyone.
Dimmi, Andrea.
I was interested in your proposal regarding trusts. And I wanted to point out that in Italy, we have legislation not with respect to the trust, but with respect to corporate disputes, where I think similar problems can arise with respect to the consent given by shareholders or others, directors. And in the Italian legislation, all organs of or bodies of the company pursuant to the law required to accept or deemed to have accepted an arbitration clause. I don't know if that exists in Australia. But in that case, I'm suggesting that your proposal with respect to trusts could also be applicable to internal corporate disputes. Thanks.
Okay.
I voted in favour of the trust.
Thank you. A decisive vote with 5 responses. Anyone else? Any other comments?
I think
this is Lucas.
Lucas, yes.
Sorry,
Please,
sorry,
Lucas.
Luke. This is Lucas. I'm sorry. I'm on mobile phone in a car, so I'm not turning on my video. But where Australian courts are engaged in a challenge to an award, and in particular on a jurisdictional basis, do you think that the consolidation under the IAA in the federal court, which I think was leading the vote count on your question number 10, should still allow a right of appeal from the federal court up to the full federal court and then to seek special leave therefrom? Or do you think that Australia should follow other jurisdictions where there is only a right to one level of review?
Well, I think it'd be a bit too much to try to exclude as much as I'd like to exclude appeals to the High Court in arbitration matters.
Well, you could be like the Swiss, like we've seen in the ZEF cases, and just allow an appeal directly to the High Court, and that's it.
Well, interestingly, in
intermediate courts altogether.
Yeah, interestingly, in Sweden, you go straight to the Court of Appeal of Svea. So you skip the first instance, you go straight to the Court of Appeal, and then you can ask for permission to appeal to the Supreme Court. But many practitioners in Sweden say that the Court of Appeal in Svea has the concentration of arbitration experience among the judiciary, and the Supreme Court has comparatively less arbitration experience. So another way to maybe sort of streamline just how many review levels there would be in Australia would be you go straight to the full federal court and then you apply for special leave if you want to go another level again.
And frequently in jurisdictional things, that's what used to happen in the federal court. We would convene a bench of 3 in the original jurisdiction, and you'd then have to go up and seek special leave, basically, and the High Court would treat that as being the end.
Yeah.
I mean, it may make sense because you've already got one jurisdictional ruling from the tribunal. Query how much benefit you get from getting 3 more.
Okay, how are we going on the poll?
I think we're ready to publish the results of the poll. It's very much on the representative sample, but we'll see what the poll shows.
All right.
So Luke, you want to take us through it?
Okay.
Can everyone see this?
Right. Okay. So let's all have a squint at this. Med Yeah, interesting arbitrability of trust disputes. Right. So obviously I didn't do a very good job of persuading people on excluding proportionate liability as a starting point. That's the least popular, and we might have a chat about why that is. But there's quite a few maybes. ArbMed, and interestingly, arbitrability of trust disputes even was less popular as well.
What was the most popular? The most popular one was enforcement of
yeah.
overwhelming.
Yeah. I think I
enforcement
might
of
have been the
emergency
only
arbitration.
maybe, because I think they're already maybe enforceable. But for clarity's sake, I'm on the record of saying early on, like, let's just make them clearly enforceable. And various jurisdictions have gone down. So, yep, so that's a kind of the obvious one. And then, good, I persuaded people on the default rule for the law being the law of the seat, presumably. And interestingly, Albert, you did well on the federal court. I think I was probably a no, because I think this was more of a problem, 15 years ago. And I think, the courts have raised their game, but you're right, there's still occasional examples where conflicting, even intermediate courts have different outcomes, and the High Court sort of ducks the issue.
Like beyond trust.
Right, and yeah, the scope of how to interpret an arbitration agreement. So, well, very interesting. Yeah.
Well, anyway, food for thought, and we just want to start the conversation. I think one of the advantages of having this sort of process is it raises the it means that people in the arbitration community start discussing these issues and not just rest on their laurels. The IAA is a serviceable piece of legislation, but it could do with some improvement, as I think this discussion has illustrated. So unless there are any other further comments or questions from the floor, our time is up.
Feel free to take a photo. Oh, maybe put up the poll. I took a photo of the results.
We can distribute it. Jackie, I'm sure, can distribute it. And on that note, as well as thanking you for all attending, I want to put out a special thanks to Jacqueline from ACCI for all her hard work in compiling that poll. Yeah. Thank you, and good night, or good morning to Andrew. Ciao, ciao.
Thank you.
Thanks all. Bye.